Good afternoon. We are happy to have you all here today. Just a couple of things. Please know that we stream our arguments now on the Supreme Court's YouTube channels. So, whatever you say goes out into the ether and stays there. So you might want to be careful about what you say and who you say it about. The other thing is, please, for the appellants, remember that you may reserve some time for rebuttal, up to 5 minutes, and just say so when you get up to the podium and introduce yourself. If there are no announcements or anything else, seeing none, would you call the first case, please?
Cotten versus Elizabeth Austin Cotten.
Can I pull this a little bit?
If it'll move, you can do it.
It moves. I'm Cynthia Cheatham. I represent the appellant, Ms. Elizabeth Cotten, and I'd like to reserve 5 minutes for my co-counsel for rebuttal.
Okay, so your co-counsel will do the rebuttal, which will be 5 minutes.
Yes, Your Honor.
Okay.
So our assignment of errors includes and primarily focuses on the fact that Mr. Cotten was given a full 50-50 custody placed on equal footing with Mrs. Cotten amidst lots of concerns by the professionals that were involved in this case, as well as Ms. Cotten herself. The designation of primary residential parent to both parents is statutorily prohibited, and I think it was conceded in Appellee's brief that Mrs. Cotten should be made the primary residential parent. However, the 50-50 with Mr. Cotten having unsupervised, unlimited, or 50-50 and his parenting not be limited in any way, no requirements for any further ongoing counseling other than the alcohol counseling that he was engaging in, where the counselor, under a self-report, determined he didn't have a problem with drinking, even though he'd had 2 DUIs and one the DUI just prior to when he moved out. And then there's the upskirting behavior. There's the taking pictures surreptitiously of Mrs. Cotten and her sister on an ongoing basis. Part of the argument that's been made is that it stopped in 2019. But 2019, by early 2020, he was in the process of filing divorce and moving out. So, and several electronics were brought up and not ever concretely turned in or turned over to the forensic experts. So I think there's a lot of fuzziness around whether or not this behavior had actually stopped. Mrs. Cotten had concerns that during exchanges he was continuing to upskirt her when she stepped on the running board of her car to get the children out of the vehicles. So whether or not he stopped, it's like Dr. Freeman said, that what we found is probably the tip of the iceberg, and that without pretty intensive intervention, the behavior would continue. It's criminal in nature. During the course of the trial, he became a felon over doing it in Florida to his sister-in-law. There was a lot made about the criminal charges, in addition to Mrs. Cotten with the drinking offering to testify if he were tried for that DUI. And I think those were taken out of context. The offering testimony for the DUI, she said that she had concerns he was going to kill himself or somebody, that he continued to drink to excess and then get behind the wheel. The pursuing criminal charges over the upskirting was primarily Kate McClinton. Both both sisters, the mother and her twin sister, who was also upskirted, were granted orders of protection against Mr. Cotten. So the statute reads that anytime there is a pattern of physical or sexual abuse or a pattern of emotional abuse to the child or of another person living with the child, then it defines steps and half-siblings.
How do we square that with the jury findings in this case? Because the jury determined that there wasn't abuse, and you're asserting that there is, and looking to protection orders in support of that conclusion, but the jury was presented with this question and said there was none. It didn't occur.
But they also, and that's a great question, Your Honor, but I think we could agree that they did make an award of a monetary award based on a finding of intentional infliction of emotional distress, which by definition caused her emotional distress. And we believe that the jury finding, several of them are internally inconsistent, and that one in particular is because, was made, we think, because they did not have the benefit of Dr. Freeman. Dr. Freeman was very clear in his testimony that it was abusive to Mrs. Cotten and by proxy to the children. When Mrs. Cotten has anxiety, they talked about the intrusive thoughts, the concerns, the hypervigilance, the inability to sleep, and those kinds of things, weight loss, inability to concentrate on her work, that it affected her parenting and by proxy the children's parenting of the children. They did find that that he did not emotionally, sexually, or physically abuse her, but gave her the award for the emotional abuse and gave her a fairly substantial award based on the unlawful photography and those kinds of things. So those are, he was committing crimes against her on an ongoing basis. The trial court, who did hear Dr. Freeman and Dr. Woodman, she limited some of Dr. Woodman and excluded Dr. Freeman altogether. And when you read their opinions, it's clear that he is abusing her. He's committing crimes against her. He committed multiple crimes against her sister, his sister-in-law. And so it's hard to square two orders of protection with this jury finding of no abuse.
Well, can't you square it by looking at 406, the plain language of 406?
Which, square it with that?
The statute. The issue here is whether or not the court should have applied a limiting factor based on 406, right?
Yes.
So it's not sufficient alone to show abuse, right, under 406. You've got to also show that it's in the child's best interest, right?
Correct.
So you could have an abuse finding and a court still determine not in the child's best interest.
Not in the child's best interest.
Yeah, because you've got two components under 406.
Correct. And that,
so where did the court go wrong? Can't we just assume, based on the outcome here, that the court must have determined, despite the abuse determination, that it wasn't in the child's best interest?
That he be limited?
Right.
I think we could, except that it says, unless it's shown by court order or other reliable evidence that he has abused these people, and it does put in the...
So is the argument here the trial court read 406 wrong, and if so, in what way?
Well, Your Honor, there was a case, and we did not cite this case, but I'd like to direct your attention to it because it specifically talks about the abuse to the parent and whether or not that is abusive to the child. And that case is Friedsam versus Crissle, and it's odd enough language that it's somewhat easy to find, Friedsam versus Crissle, Krisle. And it said that in essence, when the statute was modified, and I believe that was in 2020, to add the best interest language, that it really didn't change. That best interest was always the lodestar. It was always the guiding factor. And when we've got someone who's had at least 3 orders of protection against them. We've got 2 women who are grown-ups who it was found for him to not be safe around them. And we're going to send children that are 3 and 5 years old, unsupervised, into his care. That's concerning. And in those orders of protection, stalking was checkmarked. All of the types of abuse were checkmarked in the orders of protection. So it only flows that if adults need protection from him.
Well, I mean, but there's 2 components to the statute, and it seems like you want to ignore that in favor of creating a per se rule, which I don't see a per se rule here for that. I mean, the court, as you pointed out in the opinion that you did not cite to in your briefs, child's best interest is the lodestar here.
Correct.
You don't want us to abandon that in the case, and it sounds like the court here had some legitimate concerns about the mother in this case, and maybe her overstating certain allegations against father, and maybe perhaps that weighed against something different than substantial equal parenting time here.
And I think Your Honor may be referencing some of the child pornography things that arose.
Unsupported allegations.
Right, but both experts talked about that a 40-year-old man was looking on pornography sites specific with language for teens. And Dr. Friedman talked about where that leads.
But didn't you have 2 computer experts testify on that and give some explanation for that point?
They did,
So
Your Honor.
why couldn't the court accept that testimony over those other experts? I mean, you had 2 experts testifying on that point. You don't seem to be willing to concede that a court can credit one expert over another.
Well, no, Your Honor, both experts said it was not child pornography, and we conceded that. And we still concede that, but we still have, if you've got a woman who they said those pornography sites would have cut off at between 18 and 22 is who's going to show up when you search for teen porn. And if you've got somebody who looks like they're about 12, who's in a school uniform, in a disgusting picture, I'm not sure this mother should be taxed with or found to have noted or to understand or know that that's really not a child. There was testimony about look like a male child genitalia. Those kinds of things. There was never really any explanation except that these porn sites are not going to allow somebody that's under 18 years old. But when those first came up and those pictures were there, I believe it was reasonable for her to say this is child pornography, and then that became...
Despite there being clear proof that it was not.
Well, I don't believe she continued to say that he was viewing
Even
it.
after the proof that it was not.
I don't believe she continued to. She talked about what looked like a little girl in a school uniform, and I don't believe she ever tried to refute the experts saying that they had to be 18 or up.
So she was conceding that the computer experts here, what they agreed on, was correct.
Yes, Your Honor. But I don't think we hold that against her, that she erroneously saw someone who looked very young, who had on a school uniform, and was in that disgusting picture. And then when we look at some of the things that he was searching, it was very disturbing. He's a 40-year-old married man with 2 children looking for teens on porn sites. I mean, that's kind of how that went. And so
10 minutes goes very fast, and it looks like your 10 minutes is up.
Okay. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. Dana McClendon for Mr. Cotten. I want to drill down on the point that you raised, and I'll get there very quickly. In this case, Judge Johnson had hundreds of hours of courtroom experience with these parties. As noted, multiple orders of protection hearings. She was also Mr. Cotten's sentencing judge when he pled guilty to the unlawful photography of the sister. She knows this case inside and out. She heard the same proof repeatedly. She saw the same images and heard the same testimony over and over again. Now, one thing I learned in this case is why, although you can, you never should ask for a jury in a divorce case, because it was a complicating factor here. But she did. And as I said in my brief, you should be careful what you ask for, because you might get it. And so I would start this case at the end, when the jury returned 8 questions that she asked, no abuse, not of her, not of the children, ever, in any form, and that these parties had been 50-50 parents for years.
Was there any objection to the jury questionnaire here?
No. We
So
worked on them.
Both parties agreed that that was an appropriate question.
Correct.
Were there any objections as to the definition of abuse that were offered in this case?
There were, to my knowledge, I don't know that the definition was given.
Was there any objection to not providing a definition?
No. As I recall, counsel for Ms. Cotten wrote the questions, and then the court and I had a few comments. It's maybe not in the record, doesn't matter. The questions were given to the jury, and there is no objection in the record as to the questions presented. The jury returned all 8 questions with a negative for the abuse questions, and the jury returned in the affirmative for had these parties been 50-50 parents. So Judge Johnson also noted the same thing, because she had repeatedly put these people in 50-50 parenting, even after she heard all the evidence about the upskirting and the pornography. Because, to your point, she saw a distinction between what Mr. Cotten had unfortunately done in the unlawful photography of his wife and his sister, her sister, and a nexus to any harm to the children, who were, just as Ms. Cotten and her sister were, completely unaware of it until it was discovered on a computer years later. Presumably, even as we sit here today, the children remain unaware. And that is the question, if you read the transcripts carefully, that the court drilled down on with every expert witness, of whom there were no less than 5. 3 professional mental health experts, Dr. Freeman, Dr. Woodman, and Paris Goodyear Brown, and 2 forensic experts who analyzed the computer. And I would note, the Brentwood police got the computer as well. So out of all of this, the court, when Judge Johnson had these witnesses on the stand, repeatedly drilled down to, if the children didn't know, and neither did Ms. Cotten, and they still don't know, how could they have been harmed? And that's what the statute requires to get to this limitation. It is not a per se rule. It requires that the court start with some abuse. Respectfully, the case law and the statute don't even get us there to the abuse. But assuming arguendo, that you believe that what Mr. Cotten did would constitute abuse in spite of what the jury said, the court carefully considered in a 75-page opinion, having had the benefit of 5 days of jury trial, 2, 3, 4, or 5 more days of bench trial after that, never mind dozens of trips to the courthouse on orders of protection and other matters. The court carefully considered each and every factor and specifically found that the best interest of the children was that the parents co-parent, because the facts in the case were that Mr. Cotten had been extensively involved in the children's lives. The record is full of that. He had been consistently involved day-to-day parenting, logistics, taking children to things, involved. So by the time we got to trial, with the exception of when his parenting time had been interrupted by an order of protection that took 105 days to resolve, by the time we got to trial, Mr. Cotten and Ms. Cotten had for several years been exercising 50-50 parenting time. And the court found that it was in the best interest to do that, and even Paris Goodyear Brown acknowledged that it would be a bad idea to go backwards on that at that point. So the appellant's reliance upon 36-6406 is misplaced, because the court specifically contemplated the best interest and found that that factor had not been established, and therefore no limitation should be applied, at which point the court defaulted back to, in the absence of 406 being applicable, the best interest under the statutory criteria. And the court went through and found only one of them to slightly benefit, or even more, maybe more than slightly, advantage Mrs. Cotten, and that was the mental health and well-being of the parties, because of course, even Judge Johnson agreed that what Mr. Cotten had done was despicable and called him a creep from the bench, and later sentenced him. But she gave him 50-50 parenting time. And under the abuse of discretion standard, it is not for this court to go back and apply some emotional argument or to speculate about what might have been true if only some other device had been evaluated, or all of those things that came up at trial. It is not for this court to go and second guess and substitute a hypothetical set of facts and an emotional argument for what the trial court did here. Now I cited in my brief multiple cases where parents who had done far worse things that actually did harm the children nonetheless got parenting time. We remember in this case that Mrs. Cotten's position was that Mr. Cotten should get 0. Not limited, 0. And she had a whole host of criteria she wanted him to apply or satisfy in some way. Judge Johnson heard it over and over and over again and repeatedly returned Mr. Cotten to 50-50 parenting and wrote an incredibly well-reasoned, balanced, and factually driven opinion on the subject of the best interest of the children. So there is in the record, a credibility determination, to your point, Your Honor, that at least on the issue of reporting potential wrongs, Mrs. Cotten more than once made allegations against Mr. Cotten, or made allegations that tended to point at or insinuate Mr. Cotten, and the court interrupted at one point examination and took over for several pages, and from the bench, on the record, at the moment in time said, I don't find you to be credible about this. This makes no sense to me. I put that in my brief, and you can evaluate whether or not that factored into the trial.
Was that as to an allegation of abuse at school, though, by another student?
It was.
Okay.
It was, but it was kind of contorted and confused because the allegation, Mrs. Cotten reported to the school that her son had made the allegation that he'd been touched inappropriately, but then it came back around to he was wearing pajamas at the time. And in any event,
and that accusation was addressed to other students? Not...
presumably, except for the pajama comment, so it's not clear.
Right.
But the court's problem with it was that having made that report to the school, and the school apparently saying, well, we'll pray for you, Ms. Cotten nonetheless returned the child to the school, and that's where Judge Johnson said, that makes no sense to me. If I thought my child had been inappropriately touched at school, and I report it to the school and they do nothing, I don't take my child back there. And so at that point, at best, the court concluded that Ms. Cotten repeated something that even she didn't believe to be true in the midst, and this was right before trial. This was the second time at least that this had happened, because Mrs. Cotten had also had the daughter physically examined for evidence of sexual abuse, again insinuating Mr. Cotten's wrong, and again found nothing. Now she says she called the pediatrician, and the pediatrician told her to make the report to DCS, and so she did. But because of Mrs. Cotten's allegations attempting to gain advantage here, a little girl was examined for sexual abuse, and nothing was found. So as we stand here today, the wrong that Mr. Cotten committed, he confessed from the witness stand, and put himself squarely in criminal jeopardy because his criminal cases were at the moment unresolved. He confessed what he did. He apologized in front of the jury. He accepted responsibility for what he did, and he said what he did and didn't do. And all of this hyperbolic suggestion that there must be more, it must be worse, there must be something else, is not in the record at all. He admitted what he did, he apologized, he explained why it was confined in time. In fact, what he said was, when he had a daughter, it dawned on him how awful what he had done was, and he stopped. The situation here is that 406 does not apply. The standard, the alternative required element that the court also find that it's in the best interest of the child to limit the parenting time simply doesn't apply.
Under 406, I'm assuming 406C, which is the subpart that provides to certain criminal convictions resulting in a required reduction or a required separation of parent and child don't apply here, because that's not been argued.
I agree.
Okay.
So we are before your honors without any kind of statutory basis for a mandatory restriction on his parenting time. And even if we were, the statute, whether we like it or not, doesn't tell us exactly what that means. So while it says shall, it doesn't say in what way. But the touchstone of all custody decisions is the best interest of the children. And Judge Johnson had these parties in front of her for years, hundreds of hours of court time. She heard expert testimony from 3 mental health experts, 2 forensic experts, the parties, their families, everyone, a jury trial that went 5 days. And in 5 days, the jury came to the conclusion that there had not been any abuse at all of the children or Mrs. Cotten. And the awards were on torts like intentional infliction of emotional distress and unlawful photography. So whether Mrs. Cotten likes it or not, the jury verdict can't just be ignored because she finds it inconvenient to have asked. It's obvious that if she had known the jury wouldn't agree with her, she wouldn't have asked. But they disagreed, and she got an answer she doesn't like. And now she wants you to second guess not only Judge Johnson, but the jury verdict. And I respectfully submit that it would be inappropriate to do so. This case, I do want to take one moment and address the primary parent. I do agree with the appellant that the trial court should have picked one and only one to designate, even under a 50-50 plan. This court can quickly and easily remedy that because it's pretty obvious that the simple and easy fix here is to fix that with the designation, remand with an instruction to designate Mrs. Cotten the primary parent for the purposes of that statute. Otherwise, this court should affirm the substantive result of this parenting plan and let these people get on with their life in attempting to co-parent. I don't know whether or not the court has any questions about the motion that was pending to supplement the record.
So we've got 2 motions that have, I think, pending supplement. One you've responded to. The second one, your time has not yet expired to respond to.
My response is the same, Your Honor. There is nothing here that is capable of ready determination that would be appropriate for supplementing the record in this case at this time. It is true that there is a pending matter in juvenile court in Davidson County. That's all I feel comfortable saying. There is nothing that has been decided, no opinion, no decision, no order that can be brought here at this time that is capable of ready determination. It was inappropriate at best to suggest otherwise, that the allegations in a petition so far not submitted to trial should be added to this record in an effort to bootstrap up the argument and the emotional appeal.
Okay. Well, counsel, I mean, what I would suggest on that is if you are in opposition, it's the same as your same response, to go ahead within the time period to file that response.
I'll do that.
So that's aware, because I don't know that we'll ever take something in oral argument as being as a actual opposition to a motion unless it's filed with us.
I'll do that. I see that my time has expired. Thank you for your attention today, Your Honors.
Thank you.
Good afternoon, Your Honors. Travis Hawkins for the appellant, Les Cotten. First point I'd like to make is the issue of the jury verdict and what is clearly some inconsistency in the verdict and some of the findings by the trial court, the repeated findings that Mr. Cotten had abused his wife, a felony conviction against Mr. Cotten for...
So, I guess what I'm curious about here then, so there was the jury questionnaire, the answers clearly would conflict, in your view, with these prior orders of protection. So why isn't the appropriate step at that stage is, wait, Judge, you can't submit those questions to the jury. That's been resolved already by your orders of protection. And so because there's already been a factual finding there, that can't even go to the jury. But instead, it went to the jury, and now you're stuck with it, I feel like, unless you've preserved an objection to that, aren't you?
It's a fair point, Your Honor. However, I don't think the jury verdict should have been controlling on the judge's decision about what to do with these children. These children are, the interest of the children is paramount.
Counsel, didn't the trial court judge in her memorandum opinion indicate that abuse had not occurred?
She does say that, Your Honor.
So it sounds like the trial judge is reaching the same conclusion as the jury, so it doesn't seem, and you're saying the trial judge shouldn't be bound by that, and she seems to have independently reached the same conclusion.
I hear what Your Honor is saying. I pointed out, and we've pointed out in our brief, that she, in fact, the judge cited the jury verdict in support of the finding that there was no abuse. And I think that was an error. It was error for the judge to hear proof that the jury did not hear, and then cite the jury verdict for the proposition that there was no abuse. The judge was privy to much more expert testimony, and this is the case Burden versus Burden, where the judge essentially disregarded significant proof about abuse, how the children suffered abuse. In this case,
did the judge disregard it, or did she just conclude that it wasn't abuse? I mean, you're suggesting that it was because it impacted mother's parenting of the child, and the trial judge looked at it and said, I don't think it was abuse because the children weren't aware of it. And is that disregarding, or is that just disagreement?
However Your Honor would characterize it, we would characterize it as both. There were three experts that felt that this abuse of the mother in the case spilled over into abuse of the child. And this court has written opinions to that effect, that abuse of one parent is tantamount to abuse of one of the children.
Yeah, I
or
mean,
both the children in this
It just
instance.
concerns me that it seems like you are asking this court to sort of step over the bounds of what we are to do and get into the providence of fact-finding here. We're making our own facts based on the proof of some of the medical experts here. I mean, isn't that?
Well, Your Honor, what we're asking the court to do is to do the same thing it did in Burden, which is to find that it was an abuse of discretion for the court to disregard or disagree with three different experts who come in and say, this is abuse, and this is abuse to the children.
And so if you're looking at the sort of abuse standard, then I take it your focus is solely on it's an abuse here because it was just a misassessment of the evidence. Is that a fair description?
I think that's fair, Your Honor, that the court misassessed the evidence and also misassessed the law. The court repeatedly said, and the colloquies are in our brief, repeatedly the court said, how is this any abuse to the children? Well, committing a felony offense in the presence of your children, using your children as pawns to commit felony offenses and take inappropriate photographs of not only your wife but her sister. And we have from all the experts, Dr. Woodman and Dr. Friedman, both of them saying this is probably the tip of the iceberg of this sexually deviant behavior. I won't comment about the new DCS file. I agree that it's in a nascent stage, and there's nothing to comment on. The appellee brought it up in his brief.
But on the new DCS file, then what would be the basis for us to supplement the record for us? I mean, what could we look to then that would support supplementing records? Something clearly happened post-trial.
Your Honor, fair question. The appellee brought the new DCS. The appellee was the one that brought this up, and we just felt it incumbent to give the court the information. I realize that there's no fact-finding in that case yet that this court could rely on. However, because the appellee raised it in his own pleadings, we felt it incumbent on us to file that and supplement. We felt that the court erroneously placed the interest of the father ahead of those of the children, and taking the extra caution of seeing to it that this father had done appropriate counseling in accordance with what all the experts are saying, and to get that done, and then come back, that sensible limitations, but to go 50-50 with these children, and this father has committed sexually deviant behavior, felony behavior, and Your Honors, we gave the court the example of, blindfolding your child and letting them walk across the street, and if the child is unharmed under the trial court's reasoning, there's been no abuse to have occurred.
Your time is up.
Thank you.
Thank you.
I realize it's unusual. May I make one procedural remark? I promise you 10 seconds.
Okay.
Thank you. I brought up the DCS filing to ask the court to stay this matter, not to argue that the record should be supplemented. Thank you.
Well, thank you both, or all three of you, actually. Would you call the next case, please?